down.
Yes, sir.
Y'all can go ahead and sit down. All right. We'll hear from the appellant.
Good afternoon. May it please the court, I'm Lewis Jenkins. I'm here for Mr. Hensley, and in addition, Mr. Mansfield and I have agreed that I will argue for the appellant, so we're not going to divide any time.
Okay.
And I'll reserve 5 minutes, please, for rebuttal.
Excuse me, that'll be fine.
Before I launch into this, I wanted to say that on page 64 of our brief, there are two sets of page numbers missing. It should be a citation after the word Fogarty to the record 988 to 993 and record 1083 to 1089. I've informed Mr. Grossman that I omitted those page numbers. If one of these days, I've been doing this a long time, but one of these days, if I have an opportunity to write a bar exam question, I think I'll use this case as the basis for a bar exam question. It has so many issues in it. In this argument, we've covered everything we want to cover in our brief. Obviously, that's required. But in this argument, I would like to focus on 3 particular issues. Number one, and I think probably most important overall to the appeal, is whether or not the person who acted as a judicial officer in October of 2022 had any authority to do that. As the court is aware from the procedural history of this case, Chancellor Fogarty held office in the 4th and 5th judicial districts until either midnight on August 31, 2022, or maybe 12:01 on September 1, 2022. But in any event, he chose not to seek re-election and was replaced by Chancellor Ripley for reasons that were not clear to Mr. Hensley, and I think also to the Giesling parties. When this hearing about the enforcement of the settlement occurred on October 18, 2022, the person who showed up to act as a judicial officer was former Chancellor Fogarty. It is important to note that at that time, he held no order, no commission, no apparent authority at all. In fact, there was zero reason that, in essence, that he was not the same thing as a private citizen just walking in off the street and acting as a judicial officer. The fact that he was a former judicial officer is not any authority at all for him to conduct any proceedings in the case in any way, shape, or form. He eventually relied on 17-1304 as the asserted authority for his actions taken as in the office of a judge that day. But that statute has no application at all unless the trial of a case has actually begun. Go back to the beginning. We snipped and pasted into our brief the caption of the original public act. That statute exists for judicial efficiency, and what's now codified at 17-1304A makes that very clear. It says specifically that the trial of the case had to have begun before the term of the person ended as a judicial officer. If the trial did not begin, that statute provides no authority whatsoever to continue to act as a judicial officer after the expiration of a term. And the trial of this case had not begun. In fact, the trial of this case was scheduled in August of 2022 before former Chancellor Fogarty's term ended, but it did not occur. And it did not occur for a very good reason, because the parties announced to the court that they had settled the case. They then, after Chancellor Fogarty's term of office ended, they disagreed, as happens sometimes, about whether or not whether or not an enforceable settlement had been reached. That Mr. Hensley and the Giesling parties filed motions to enforce the settlement, and that was opposed by the Slattery parties.
How was this settlement announced to the court? Was it outlined to the court as to what the terms and conditions of the settlement were?
So it was announced to the court in a telephone conference, Your Honor, and the terms of the settlement were outlined between the parties in an electronic mail message that appears at pages 746 and 748 of this very long record.
Now, this was during his term, though, right?
It was, yes, the settlement was reached during his term, and the announcement that there had been a settlement was reached during his term, because the original trial, which was not held, would have been during former Chancellor Fogarty's term. Yes, sir. So the first issue, and I think the straightest line through this case is to determine that an enforceable settlement existed. But the problem is, on the record before this court, it appears to me that this court can't get there because of the invalidity of the action by someone who was not a judicial officer in October of 2022. And so, but if this court determines that it can get there, and the way there obviously would be that Chancellor Fogarty was later appointed a special judge and essentially he did not make the same ruling. He made an amplified ruling, which purported to give additional reasons why the ruling had been made at the time that it was not valid in October of 2022. But he later made an order that there had not been an enforceable settlement reached. That should not have occurred. He should not have acted as a judicial officer for the reasons that we've set forth in our brief at that time either. But if the court reaches that issue, then it's clear that electronic mail message that appears at 746 and 747 satisfies the statute of frauds, and it satisfies the elements of a contract. In other words, it demonstrates mutual assent to a meeting of the minds. Mr. Terry sent it. Mr. Grossman said that is agreed. And then the terms of the settlement were specifically outlined in the email message.
Did it describe the land to be transferred?
It did not, Your Honor, but the parties later had a survey conducted to which there was no disagreement that was the land that was to be transferred, and that survey appears at 748, and it was used in the proposed expanded agreement that was submitted by the Slattery parties. I do not think that there's any support in this record that there was ever an actual disagreement about what the description of the land was. There was a survey that was conducted under the supervision of all the parties, and it was filed in the trial court. It appears at one copy of it appears at page 748 of the record, Your Honor. And so that was the trial court, and appears to be the appellee's only basis for resisting the enforceability of the settlement, if I'm reading their brief correctly, that the original email lacked a sufficient description. But I think that was cured. If in fact it was true, it was cured by the fact that there was a survey that I don't think anybody disputed contained the land that was to be transferred. There were other disputes about the terms of that expanded settlement agreement that eventually, I think, caused the thing to fall apart. And that's what led Mr. Hensley to seek to enforce the original settlement agreement. And that's not uncommon. That happens in mediations. That happens in all kinds of contexts where parties reach an enforceable settlement. And in fact, I've read a case that will submit a supplemental authority later on, the extreme excavating case, where that was recently decided by this court, in which that very same thing happened. But I'm not going to argue about that. I'll submit the supplemental authority letter so Mr. Grossman has an opportunity to respond to that. That fact is demonstrates that there was an enforceable agreement. The final thing is that even if we're wrong about the settlement, even if we're wrong about the jurisdictional issue and the authority to act as a judicial officer, it was wrong to dismiss this case because that made Mr. Hensley bear all of the consequences of the parties' admitted breakdown in the settlement they thought they had. I'll come back for rebuttal.
Yeah, you have your time for rebuttal. We'll hear from the appellee.
Good afternoon.
Afternoon.
Matthew Grossman, along with Rebecca Harbin, among others. We represent Mr. Slattery. There he is. Anyhow, Your Honor, I appreciate counsel kind of narrowing down the scope. I'll talk a little bit outside of that scope, but I'll also address some of the things that Mr. Jenkins brought up. I will agree, and as Chancellor Fogarty stated more than once in the record in this case has a tortured procedural history. And I'll give the basic timeline here just for a little bit of flavor. Okay, this lawsuit was initially filed in Sevier County in 2016, filed also in Jefferson County in 2017, and then in 2018, on behalf of my clients, I filed a motion to dismiss that was two-pronged. First, the first basis was failure to state a claim, and the court indeed granted that relief in part. We were basically seeking to have common law easement remedies dismissed, as well as an attorney fee claim dismissed. Those were in fact dismissed by that motion to dismiss. The only reason I bring that up is the plaintiff's brief seeks to place the onus for everything that happened here on defense counsel, and that's simply not the case. Again, this 2018 motion to dismiss was two-pronged. Its first is a 12026, and then I believe that's a 12027 for failure to join the necessary parties. Most concerning to my client was the lack of inclusion of TVA in the case, and that's not because we're going around trying to find parties to add to the lawsuit. We did that because my client's property is subject to a flowage easement to where if we do things in that flowage easement that TVA disagrees with, we can have potential liability to TVA. That's the principal reason we were concerned about TVA not being in the case. Obviously, Chancellor Fogarty agreed with us. Obviously, this was back in 2018, well before any of these other misfortunes in this case occurred. And obviously, in that same order in 2018, the Chancellor specifically said anybody that wants to cross Slattery has to add TVA, and also said and any other parties that might need to be added to the case. Obviously, when TVA was added, they removed the case to federal court, and the federal court disagreed with Chancellor Fogarty that TVA was a necessary party. Again, we respectfully disagree with that, but again, this is not an instance where, as one reading the plaintiff's brief might infer, that Mr. Slattery is somehow just trying to muck up the works. These are all legitimate concerns that my client had. So in January of 2020, the case, after the Sixth Circuit affirmed the district court, the case is remanded back to the trial court. Just as a matter of background, trial court there has its docket soundings in November, so we'd already missed that date. So we get to the November 2020 docket sounding, and we got dates for 2021. And we had at I don't know if it was a pretrial conference or just a hearing that happened to predate the trial, among the things that came to the court's attention was that the plaintiff and the cross plaintiffs, the people seeking the easements, had not added lien holders on the property that the road that the plaintiff sought to condemn, where those interests, we have interest holders in the nature of liens, trust deeds, things of that nature. And Chancellor Fogarty, in that hearing, this is in the record, said, well, those guys need to be here because, and for obvious reasons, if there's a foreclosure and they're not joined, these proceedings are meaningless. You have to do the whole thing over again. And so that was what ultimately resulted in the continuance of the trial in 2021. Again, this is not the doing of the defendant. This is the failure of the plaintiff to identify who needs to be named as a party in a statutory private condemnation case. Again, so ultimately they added the plaintiff and cross plaintiff, they added these additional lien holders. But that's why we missed this trial date in 2021. And it's supposed to be a 3 or 4 day jury trial. In rural counties in Tennessee, trial dates are precious. Chancellor Fogarty, 4th and 5th districts, that's 5-county district. And I dare say the court can take notice, Jefferson is far from the largest. So for the court to hold those days and then surrender those days is a big deal. Again, so what happens the following year? Essentially what happens is the trial was abandoned. There are pretrial orders that even the default order says, default is granted as to the right to do the taking, but the value has to be set out by the jury. No agreement between my client and the plaintiff, which we dispute ever existed, has any bearing on the plaintiff's obligation to prosecute that case as stated in the court's order granting the default. And that would have been in around June or July of 2022. Basically, and again, I don't believe there's anything in the record that says I participated in any phone call with the court or anybody from Mr. Slattery participated in any phone call with the court announcing a settlement. I think Chancellor Fogarty mentioned in both from the bench and in some rulings that the parties informed the court of a settlement. That certainly doesn't mean that we ever said that. Now, and again, as the court's well aware, Chancellor
There was an announcement of a settlement?
Pardon me, Your Honor?
The case was not settled? It wasn't an announcement of the settlement?
I believe what happened is plaintiff's counsel called the court, announced it was settled, but there's nothing in the record that indicates who participated in that. I will state, Mr. Terry and I had these emails, and he proposed some bullet points, and I stated, this is agreed. And those bullet points, were agreeable, but they didn't, and I'm kind of skipping ahead there, but those bullet points did not make a settlement for the various reasons that Chancellor Fogarty pointed out in 2 different orders. First off, there is no legal description in this record that ties into this potential settlement agreement. Mr. Jenkins refers to page 790 in the record, and also I guess there's 748, I think, is where this map may appear. 2 things about that. There's not a speck of evidence in this record that survey or whatever it is was ever agreed upon by the parties or incorporated into this settlement agreement. And indeed, the settlement agreement required the parties to agree on it. And that would have to be in writing under the statute of frauds. And again, whether this survey was ever incorporated into the settlement agreement is not something that was ever presented to the trial court. I went, just this morning, I went through all these motions. I couldn't find where anyone representing the plaintiff or the cross plaintiffs ever said, here's the survey, this is what we agreed on, and made that argument to the trial court. So to the extent that that argument is made, it fails as a matter of law because there's no indication that it was ever agreed to by the parties that are to be bound. Right. And also, that's just not an argument that was made.
Taking all that as accepted for purpose of my question, what you're arguing here, then the trial court dismissed it for failure to prosecute. Is that correct? Is that what ultimately happened?
And without prejudice.
Without prejudice, but still dismissed it for failure to prosecute. Why?
I think the
I
trial.
mean, it seems like there were, from what you said, that there was plenty of I don't want to use the word blame, but plenty of causes for why the delay to go around. Why dismiss it? What was the basis for dismissing it? For failure to prosecute.
As far as the 2021 goes, because I think we need to back up to that, is the court almost dismissed it then because the case was set for trial at the docket sounding. Under the local rules, if you set it at the docket sounding without an objection, it needs to get tried. And here, again, we're talking about precious trial dates in a rural county. And that's what happened here is the plaintiff announced this case is settled. Again, there's nothing in the record that demonstrates how that occurred, and it wasn't. And on top of that, we still have the court's order saying, as far as these defaulted parties go, we still have to have the jury trudge around out in the woods and do the jury of you thing, which did not happen here. And by failing to appear, that's what happened. And again, Chancellor Fogarty stated in his memorandum, or memoranda for that matter, that this was, in fact, the oldest case on the court's docket. And he also stated that it had been given more court time than any other case presently on the docket, and that it needed to be dismissed as a matter of docket control, which, again, we cite in our briefing that is certainly something that the trial court can do to manage the docket.
All right, run me through again quickly the things that caused the delay.
Okay, what happened? Okay,
Not who, just right now, just tell me what they were.
The lawsuits filed in 2016 and 17. 2018 is when the case was removed to federal court. I believe that was in May of 2018.
All right, who asked that it be removed, or how did it happen?
The Tennessee Valley Authority.
Tennessee Valley asked that it be removed. Okay.
Correct. And that was basically they filed a motion to dismiss, and that's what happened. Case was remanded back to the trial court in January of 2020. So again, the case was dismissed more than, I would say, 30 months after it was remanded back to the trial court.
What happened after it came back remanded to the trial court?
About all that happened between it being remanded and going to the docket setting and getting the 2021 trial dates, to my recollection, is I believe we might have had some scheduling conferences, things of that nature.
Okay. And then according to you, plaintiff lawyer, just by himself, I guess, calls up the court to tell them that the case is settled.
That's all I know.
And you're saying that's all the record shows?
That's all the record shows, and trust me,
Right.
I've scoured my records to see if I
Okay.
ever was involved in that. I can't find it.
Anything
Again,
showing they didn't believe? I understand you disagree with them, that your position is that it wasn't settled, but, okay. So that happens. Then what happens next?
Well, what happens after that is the motion to enforce is filed by the plaintiff. We file the motion to dismiss for failure to prosecute.
Okay.
That's what brings us into
And then it gets dismissed for failure to prosecute?
Yes, Your Honor.
All right.
And again, we believe that is well within the trial court's discretion to do so. And again, it's without prejudice.
Before you run out of time, you might talk about how Chancellor Fogarty had the authority to continue doing this after he...
Well, I'm glad you asked, because I definitely,
I'm glad you're
that's one of the more fun topics we have here today.
Yes, it is.
Okay, as far as the beginning of the trial, things of that nature, I will defer and just adopt what Chancellor Fogarty stated in his two different orders that address the issue. Now, so we have essentially four different ways that Chancellor Fogarty could have acted. We've got the de jure, which is whether that statute allows him, holdover. Whether these proceedings amounted to the commencement of the trial. Again, we agree with Chancellor Fogarty. Now we have essentially two that I think are really the same thing, which are de facto, judge, and waiver. I think it's very important for the court to note that in early October, and this appears in the record, Mr. Parker, who is co-counsel for the plaintiff, emailed Chancellor Fogarty directly and copied other counsel saying, we want a hearing in front of Chancellor Fogarty to address this, which was Chancellor Fogarty sent out an email in October or a letter to the parties saying, waiting for your order. You said this case is settled. Where's your order? And rather than go to Chancellor Ripley, counsel for plaintiff went directly to Chancellor Fogarty and said, we want a hearing in front of you. And indeed, as far as de facto, because I think everybody should be able to agree that Chancellor Fogarty, regardless of the de jure issue, Chancellor Fogarty believed in good faith that he was acting during his rights as a holder.
Is that enough?
Yes, Your Honor. And because what happened
Why?
here is...
Do you have any case that says if the parties ask some non-judge to rule on their case and the judge believes, or the person believes that they can do it, that gives some kind of judicial position to the individual?
Yes, we cited to some of that, Your Honor. And this was Supreme Court in Martin versus Dowling, 315 Southwest 2nd, 397 at 399. Judicial acts of one in possession of a judicial office created and existing by law under color of right, assuming and exercising the functions of such office with a good faith belief in his right to exercise such authority, invoked and acquiesced in by the parties, the bar, court officials, and the public are those of a de facto officer. And what I was going to point out is, in addition to asking Chancellor Fogarty to hear these motions, at that same hearing on October 18 of 2022, the plaintiffs presented a consent judgment to Chancellor Fogarty, which is all the more of a de facto issue and a waiver and acknowledgement that everybody believes he's acting with due authority. Chancellor Ripley was in the courtroom, and the record reflects that. They could have said, Chancellor Fogarty, nice to see you. We want this guy on the bench. He's the chancellor. They didn't do that. And so that pretty much takes up my time. But I think in the absence of this court finding that Chancellor Fogarty was at the very least acting as a de facto judge, it's essentially granting the plaintiff another bite at the apple. And again, one thing I would point out is I think all that is rendered moot. I know I'm past time, but all that is rendered moot by the fact that the Supreme Court in 2023 appointed Chancellor Fogarty to hear all cases in which Chancellor Ripley recused. Again, there's an issue that plaintiff raises in the recusal motion relating to choosing your successor, but I think Chancellor Fogarty ably addressed that in his ruling on the motion.
Thank you.
Thank you very much, Your Honor.
We'll hear from the appellant in rebuttal.
Thank you, Your Honor. So let me just say that, the judicial authorities, exactly like subject matter jurisdiction, there's no way that any of this constitutes a waiver. But Mr. Grossman is relying on something that former Chancellor Fogarty acknowledged was not true. And that is in the transcript of 31 October 2023, we pointed out to Chancellor Fogarty that the consent judgment issue was incorrect, that had been sent with a letter, and that letter specifically said that it was wanted to be entered by Chancellor Ripley, who was then the Chancellor. And Chancellor Fogarty acknowledged at page 7 and 8 that it was the clerk pulled that letter out. I guess it's not under Rule 24, it's not part of the record, but he pulled it out. The clerk pulled it out and showed it to him, and he acknowledged on page 7 and 8 of that transcript that was incorrect. It is wrong that consent judgment was ever presented to anybody other than Chancellor Ripley by the plaintiffs in the case Mr. Hensley. But back up and look at this Chancellor Fogarty said the entry of a default judgment was the beginning of a trial. My disagreement with that statement is so profound that it's difficult for me to say anything respectful about it, because there is no authority that a default judgment is the beginning of trial. That is not true. There's never been a case that said that. There's never been a law dictionary that said that. There's never been a treatise that said that. There's never been anything that said that, because it's not. The one case I could find is that Sixth Circuit case that talks about what a trial is. Of course, the definition from Black's Law Dictionary that we cited in our reply brief. The trial is the time from the impaneling of the jury, or I would say from the beginning of opening statements in a bench trial to the time of a verdict is rendered, a judgment is a verdict is rendered, not a written judgment in the case. There's no authority for the proposition that trial had begun in this case, because it absolutely had not. We think there was an enforceable settlement. Mr. Grossman replied, and that email, which is in the record, says, Mr. Terry ended by saying this: this will also resolve the cases. This will confirm that Mr. Slattery, Giesling, and Hensley have agreed to settle this case. And then there's some terms. And then Mr. Grossman replied, this is agreed. That's on page 746 of the record. And as to the timing issue, our brief should not be read as trying to blame this on Mr. Grossman, which is what he said. But the simple fact of the matter is, the largest chunk of time between filing and the time the case was dismissed was consumed by two things. Number one, the inclusion of TVA as a party. TVA disagreed that it ought to be made a party. Judge Reeves at the district court disagreed that it ought to be made a party. The panel decision from the Sixth Circuit, which involved 3 judges, basically said this argument has no weight whatsoever. TVA should not be a party in this case. The plaintiffs couldn't have been responsible for that. It was Mr. Slattery, and it turned out that he was completely wrong about whether or not TVA ought to be included in the case. The second thing was this addition of these 80-some parties that the trial court mandated after Mr. Slattery made a motion asking to include all these parties. Under the Barge versus Sadler case, that order mandating the inclusion of those 80-some parties is simply indefensible. The Barge versus Sadler case says that the trial court's got to evaluate whether or not the plaintiff's in control first of who the parties are, and second, the trial court has to evaluate whether or not there's a reasonable possibility that any easement can go across that land. There was no evaluation. There was just an order that said, add everybody who owns land in this subdivision. That's what took up the time, and I'm out of time, so I'll stop.
Question.
Mr. Jenkins, what are you asking this court to do at this point?
I wish I had been able to sit down without you asking me that, Your Honor, but I guess it's a fair question. So if there's a path, if there's any path under which this court is able to review the action of the trial court when we claim there was no action of the trial court that by a person who had authority to do that, then we're asking for this court to enforce the settlement. But I think it's a difficult question as to whether or not this court can enforce a settlement that's never been properly ruled on by a trial court. And so I think that this case has got to be, all the orders made by Chancellor Fogarty must be must be vacated, and this case has to be remanded to the trial court for a hearing by a judicial officer who has authority and who is not Chancellor Fogarty, former Chancellor Fogarty, to determine whether or not a settlement occurred. But if this court disagrees with me about the jurisdictional question, then we're asking for this court to enforce the settlement as it was written in that electronic mail message. Does that answer your question, Your Honor?
You told me what you want.
Yes, sir.
Thank you.
Okay.
Yes, sir. Thank you, and thank you for allowing me to argue.
Our thanks to both sides.
Thank you, Your Honor.
Appreciate your arguments and your briefs on this.